Okay, we have seen appointment, we have seen qualification, we have seen vacation. Now we are looking into removal of directors. Yeah. Now, Section 206, Section 206, Companies Act 2016 says the director may be removed before expiration of the director's period of office as follows. First one, subject to constitution in the case of a private company by ordinary resolution. For the public company, it will be in accordance with Section 206. Okay. Now, Section 206, Subsection 3, removal by ordinary resolution at a meeting before expiration of the director's tenure of office, notwithstanding the provision of the Constitution or any agreement between director and company. So, for public company, it is actually by ordinary resolution as well. Now, the case of Tuan Ishak Ismail, Justice Court of Appeal, Shankar says, a public company may, by ordinary resolution, which is simple majority, remove a director by exercising the votes of its shareholder. Okay, same thing like the private company, ordinary resolution, when you want to remove. Now, in the case of Solapan and Lim Yok Fan, in this case, their articles provide that director may be removed provided that 7 days notice had been given of any general meeting. Okay. Plaintiff want to remove all the directors. The first plaintiff sent notice of resolution to remove the directors 3 days prior to the meeting. Okay. The plaintiff were elected as new directors and brought as action as the defendants refused to vacate the office. Okay. Now, trial judge held that the 28 notice is required before the old directors could be removed. This was the old section 128 of the Companies Act. Because the plaintiff were not properly appointed. Now, however, Federal Court says that Section 28 of the Companies Act 1965, basically the 28 notice, was not mandatory. The power is coexisted with any power in the article. So, if you have a lesser days of notice in the Constitution, you must follow the Constitution. So, a short notice in the article could be used to effect a removal. However, the proper 7 days notice in the Constitution itself was not followed in this case. Okay, so that's why the defendant had not been properly removed. Thus, plaintiff were not properly appointed as directors of the company. So, despite it's a shorter notice, right? But you should follow the Constitution. Okay. Now, Section 206, Subsection 4 of the Companies Act 2016 says, a resolution to remove the director does not take effect in case of him was appointed to represent the interests of a particular class of shareholders or debenture shareholders until a successor has been appointed. Meaning, if you are the directors, you representing shareholders or debenture holders, you cannot be removed unless you have found the successor. Okay. And then what are the procedures? Section 207 states for the procedures for the right to be heard for directors against removal. Now, the procedures are summarized as follows. Firstly, special notice is required of a resolution to remove a director. And upon a special notice, now special notice means you give 28 days. Ordinary resolution normally we give 14 days. Special resolution is for 21 days. But for special notice, the notice, the length, duration for the notice to be given is 28 days. So we call it special notice. Upon receiving special notice, company shall forthwith a copy of it to the director. And then director shall be given the right to make oral or written representation not exceeding a reasonable length on the resolution to remove him. And then if the director make a written representation and requests the representation to be notified to the members, the company shall state the fact of the representation in a notice of resolution given to the members and send a copy of the representation to every member of the company. So basically, the members knows what's going on. Okay. And then in the event the representation are received too late by the company to do so, or due to the fault of the company, the director may request that his representation be read out at the meeting. So by right, the member should be given written representation. So if there is late, in distributing, so those representation should be read out during the meeting. And copies of the representation need not be sent out, and representation need not be read out if on the application of either of the company or of any person claimed to be aggrieved. So basically there's victim, okay, and the court satisfied that the rights conferred by the provisions are being abused. So you don't need if the company or the person claim of being oppressed or something like that, and the court satisfied that the rights conferred by the provisions are being abused. So you don't need to read out the representation. Now, court may order the company's costs to be paid in whole or in part by the director, notwithstanding he is a party to the application. Now, for this section 207, this is on the procedure of removal of a director in a public company. And for those aggrieved on the removal, they can actually apply to the court, and the court has the right to decide. Okay. Now, compensation for loss of office, section 227 prohibits the company from making a payment to director by removal of compensation, by way of compensation for loss of office, unless particulars in respect of the proposed payment, including the amount, has been disclosed to the members. So basically, if you want to compensate, you must disclose the amount. And the resolution for the proposal has been approved by the members, okay? And when such payment has been unlawfully made and the amount has been received by the director, shall be deemed to have been received by him in trust. It means here, if the director has already received the money, the director has to repay back. If he's not repaying back, he holding the money as a trustee. Now, any payment referred to in section 227 shall not include any payment under agreement entered into before the commencement of the act, or any payment under agreement where particulars have been disclosed and approved by special resolution, any bona fide payment by way of damages for breach of contract, any bona fide payment by way of pension or lump sum payment in respect of past services, and any payment to a director under agreement made between the company and director as a consideration or part of a consideration for the director agreeing to serve the company as a director. So you will not include this compensation. So the compensation for loss of office is something like, here I remove you, this is the money being compensated, provided members approve it. Okay. And then what about loans to directors? Basically, under section 224, company other than exempt private company cannot make a loan to directors or any of the persons in connection with the director. However, provision does not apply if it was meant to, what happened here? If it was meant to meet the expenditure incurred by the officer for the purpose of the company or enabling him to perform the duty, or the provisions of fund to a director who is a full-time employee of a company or is holding company to purchase or acquire a house. So I suppose there's a fund where they can obtain loan. Or a loan made by the company to a director who is a full-time employment of a company or is holding company, where the company has passed resolution to approve the scheme for making loans to employee. So basically, a company other than exempt private company cannot make any loans unless it falls within these three provisions. And then section 225 again also prohibits company to give loans to any persons connected with the company, except where the loan is made or guarantee is provided in relation to a loan made to a subsidiary or holding company or a subsidiary of his holding company, or the company ordinary business is lending of money, or any loan made to a person connected with the director who is engaged in the full-time employment of a company. Okay, these are the three exceptions. Now, who are persons deemed to be connected is governed by section 197, whereby they are deemed to be connected with the person if they are member of the director's family, a body corporate associated with that director, a trustee of a trust other than trustee for an employee's share scheme or pension scheme, under which that director or a family member is a beneficiary, or a partner of that director or a partner of a person connected with that director. So these are the people who we consider as connected with the director. Now, a member of the director's family is also further defined under Section 197, Subsection 2, Paragraph A of the Companies Act to include the director's spouse, parent, child, including adopted child, stepchild, brother, sister, and the director's child, brother or sister. Okay, and it doesn't include your brother-in-law, sister-in-law, mother-in-law. Okay, now Section 197, Subsection 2, Paragraph B, they have defined when does body corporate associate with the director. When the body corporate is as custom or is under obligation, whether formal or informal, or majority of directors is accustomed to or to act in accordance with the direction, instruction of that director, or when the director has controlling interest in the body corporate, or the director or persons connected with the director are entitled to exercise not less than 20% of the votes. So this is when the body corporate associated with the director. Okay, the next one, the last part, the division of powers between the board of directors and the general meeting. Section 211 says that board of directors has all the powers necessary for managing and directing and supervising the management of the company. And basically, the inability of the general meeting to interfere with the powers of directors, whereby if the constitution give the directors, the general meeting cannot actually remove those powers, okay, unless you firstly amend the constitution. This is given by the case of Ri Chi Leong and Son. Okay, then there are specific provisions in the Companies Act where directors may not exercise powers with the approval of the company in general meeting. This is on disposal or acquisition of company's main undertaking, acquisition or disposal of non-cash assets, or issue of shares by directors, a payment made to directors upon retirement or resignation under Section 205 or Section 196. So these are where you need the approval, okay, of the company in a general meeting. So what I've given you is actually basically reproduction of the whole sections of the sections in the Companies Act pertaining to directors. Please have a look in detail on each of the clauses. Okay, thank you very much.